Hi, it's Mike DelSignore, Massachusetts OUI lawyer. Today's video, I want to talk about what happens if you are arrested for OUI, and your case is going to be heard in the Quincy District Court. Quincy's a court where they hear a lot of OUI cases. State police makes a lot of arrests in that area. You got 95 going through 93. A lot of people coming back from Boston will be stopped in the Quincy area. So what should you know about Quincy District Court, and what should you know if you're charged with first OUI? First, these are winnable cases. It's easy to get arrested for an OUI if the officer smells alcohol. It's late at night. Very good chance you're going to get arrested because officers only need very little evidence to make an arrest, probable cause. The standard changes drastically at trial. Now the burden of proof is on the government. It's proof beyond a reasonable doubt. That's why many OUIs result in not guilty verdicts. Take field sobriety tests. These tests that are often the basis of you being arrested can be challenged in court. Many times people do better on the test than they think. Many times there's details in the report that are left out. And when I cross-examine the officer, I'll be able to show that you basically substantially performed. You might have done some things wrong, but what you did wrong doesn't show impairment. There's different ways to attack these. In some cases, we present medical evidence. My favorite argument, and yesterday I had a trial where I presented medical evidence. My client had a back issue, but my argument was, I said, Judge, I think the client passed the test. I think these tests didn't show impairment. To the extent you thought there might have been any issues with balance, could have been from her back. So my argument was the test passed. To the extent there were any issues, they certainly weren't from alcohol. So sometimes you can use both. You can say, one, the cross-examination, the testimony of the officer shows that there were really no major observations. So what I look for is stumbling, staggering, major signs. I like it when people take the correct number of steps. I can say basically they got the gist of the test, and what was wrong might be some little fine details in the exercise. Next, so field sobriety test can be challenged, attacked in court, and establish reasonable doubt. Next, we try to minimize any claims of bad driving. Often people make mistakes driving. Sometimes you're distracted on the road. There's a lot of reasons why somebody may cross the marked lanes, cross the center line that are not related to alcohol. So keep that in mind. Accidents can be caused by different things. The final part of a case, so you got the driving, the field tests, the booking. Often people are polite, cooperative, respectful. That can be used to show reasonable doubt. If you took a breath test, those tests are not automatically admissible in court. There are ways to exclude those tests from evidence. So keep in mind your case still winnable even if there's a breath test. Sometimes there's bad evidence in the case and we can put a case on for a motion to suppress. Recently I had a case where I thought the case was great, but I was concerned about the alcohol. There was alcohol in the car. I did a motion to suppress, got that excluded, made the case better for trial. It works with statements too. Sometimes if you say to the cop, I had 4 or 5 beers right initially when the cop approaches the car, it's probably going to come in. They're not required to read you Miranda that quick. But if it's after the field sobriety test, and this comes up a lot, after you do the field sobriety test, the officer thinks you failed. The officer says, it seems like you had more than the 2 drinks you told me. If you say more, that might be a statement that could be excluded under Miranda. So those are the different ways we can challenge a case in court to try to establish reasonable doubt and get a not guilty. Exclude a breath test, challenge the field sobriety test, minimize any erratic driving. So what you should know, the arraignment, your first court date, you're going to enter a not guilty plea, get a further date for pretrial. First court date's not a trial. You're going to be notified of the charges and given a copy of the report. You can't get the report before the arraignment. Common question people ask. First offense OUI is a misdemeanor. Another common question people have. If you have questions, you can always reach out to me, but in this video, I just want to go over some of the common things. When can you get your license back? If you refused a breath test, 30 days you can get your full license back. You need to request a hearing with the RMV over the phone. So do that before the 30 days ends. You should almost do it almost immediately so you can schedule it on day 31. You refused a breath test, it's a 6-month suspension. So if you could get a trial prior to the 6 months, you might be able to get a judge to allow a motion to reinstate. On a first offense, I wouldn't try to appeal the refusal to the RMV in Boston. I used to do that. If you've seen it on any of my old videos, I think they're all down, but ignore it. The RMV's taking out immediate threat suspensions for people who appeal the refusal. So don't go there because it'll just make your situation worse. So if you have questions about an OUI offense in Quincy, contact me, call, text anytime, 781-686-5924. My name is Mike DelSignore. My passion is helping people make the best decisions for themselves when charged with an OUI offense, and I can help you with your case.